If we could have a staff briefing on 1591, please.
Certainly. Good afternoon, committee members. For the record, Michelle Rusk, staff to this committee. Before you is House Bill 1591, providing remedies for defendant survivors of domestic violence, sexual assault, or human trafficking. For your background, Washington's Sentencing Reform Act established a determinate sentencing system where courts impose sentences in a standard range using a grid based on someone's prior criminal history and the severity of the present offense. Sentences may be increased or decreased by other sentencing policies like sentencing enhancements or aggravating or mitigating circumstances. The SRA also defines or provides penalties for offenses of domestic violence, sexual assault, and human trafficking. Victims of domestic violence are intimate partner or household members who have been subjected to the infliction of physical harm or sexual and psychological abuse by an intimate partner or household member as part of a pattern of assaultive, coercive, and controlling behaviors aimed at achieving compliance or control over the intimate partner or household member. DV offenses include but are not limited to stalking, assault, and coercion between intimate partners and household members. Victims of sexual assault are individuals who are the victim of a sexual assault offense, non-consensual sexual conduct, or non-consensual penetration who suffer physical, emotional, financial, or psychological impacts as a result. Sexual assault offenses include but are not limited to rape and child molestation. The Sentencing Reform Act also prescribes penalties for trafficking offenses, which occurs when a person recruits, transports, obtains, buys, purchases, or receives by any means another human, knowing or in disregard of the fact that fraud, force, or coercion will be used to cause that person to engage in conduct such as forced labor, involuntary servitude, or sexually explicit acts. Turning to the bill before you, House Bill 1591 establishes the following three remedies for defendant survivors of domestic violence, sexual assault, or human trafficking. First, the authority to impose a new sentencing alternative or reduced sentences. Second, resentencing for these defendants. And third, authority to vacate convictions. Turning to the first remedy, the bill authorizes courts to either impose a reduced sentence or a new sentencing alternative when sentencing a defendant for one or more crimes who meets the following eligibility criteria. At the time of the offense, the defendant must have been a victim of domestic violence, sexual assault, or human trafficking, and subjected to substantial physical, sexual, or psychological abuse inflicted by an intimate partner or family or household member. The DV or abuse the defendant suffered must have been a significant contributing factor to the defendant's criminal conduct, and generally applicable sentencing requirements would be unduly harsh, given the nature and circumstances of the crime and the defendant's history, character, and condition. In this briefing, I will refer to this criteria as eligibility criteria. The bill directs courts to consider specified factors to evaluate whether the DV or abuse was a significant contributing factor to the criminal conduct, and allows courts to consider many different types of evidence when evaluating if somebody meets the eligibility criteria. If a court finds a defendant does meet the eligibility criteria, it may do one of the following: impose a sentence below the standard range and ending mandatory minimum, depart downward from a sentencing enhancement, or impose the new sentencing alternative. The new sentencing alternative authorizes a court to waive the standard range sentence and instead impose a term of confinement, a reduced term of confinement and extended community custody, or no term of confinement and an extended term of community custody. Courts must impose this sentencing alternative if someone meets the eligibility criteria and the court finds the alternative is appropriate. Several requirements are imposed on individuals who are given an extended term of community custody under the sentencing alternative, including that the court may order the person to serve a term of total confinement. Turning to the second remedy, courts are given authority to resentence a defendant who is currently incarcerated, serving at least an 8-year sentence, and meeting the eligibility criteria. The bill analysis goes into much greater detail about the evidence that a petitioner must provide and the procedure around whether and how a court may deny a petition and conduct a hearing. The third remedy is authorization for courts to vacate records of conviction for survivors of domestic violence, sexual assault, or human trafficking. A court may consider the same factors and evidence it would have considered for imposing the sentencing alternative, but it also may rely solely on a person's sworn testimony if it chooses to. If a court finds someone eligible, the court may, in the interest of justice, waive all statutory restrictions relating to vacating convictions and vacate the person's record of conviction.
So I'm going to ask the prime sponsor from the 30th District to make a presentation.
My name is Representative Jamila Taylor from the 30th District, and I'm honored to bring the Survivors Justice Act to you for your consideration. I work in a space of crime victim services prior to coming to the legislature. I was the statewide advocacy counsel for Northwest Justice Project, and it's a large network of attorneys working to support survivors in their domestic violence cases, both criminal and civil legal aid. And we've seen that there are so many survivors who get involved in the criminal justice system who it was a race to the for example, it was a race to the police to make a call, and they end up the ones ultimately convicted of assault, convicted of a crime involving their abuser. This particular bill will address a lot of those issues where the impacted survivor has ended up in the criminal justice system in an unjust way, and gives them an option to ask the court for mitigating factors around their survivorship so that they truly can be heard in the whole legal process. We understand that there's a concern around the fiscal note for sentencing, and I know that this bill evolved out of Rep. Simmons's bill from last year, and we thought a more strategic direction this year would be helpful, but I really ask this committee to take serious consideration of how we can help survivors who have been entangled and sometimes permanently entangled in the criminal legal system as a result of their victimization and manipulation. And you can imagine if you're a domestic violence survivor who has a criminal legal background, and that in and of itself is victimization by an abuser. And then again, I can go on for all kinds of scenarios, and I know you have a long agenda today, so I just want to make sure that you understand that, you know, the face of survivorship is complicated, is deeply entrenched in community, and sometimes you just don't know who is a survivor. You might be sitting next to a survivor, you might be talking to a survivor, you might be the survivor who's consistently misunderstood. So I ask for your consideration.
Well, I'm talking to a survivor, and I'm sitting next to a survivor. So, and I'm the number 2 on this bill, and so I very much understand these issues, and incredibly important. And I will ask David Martin from the King County Prosecutor's Office to make the initial presentation here. David?
My name is David Martin. I supervise the Domestic Violence Unit of the King County Prosecutor's Office. I am here as a representative of my office in support of 1591, the Survivors Justice Act. I grew up in a home with domestic violence and have spent the last 25 years prosecuting domestic violence cases. I've seen firsthand how trauma shapes decisions, limits options, and traps people in cycles of abuse. For decades, Washington law has recognized the impact of trauma, especially in context of domestic violence and sexual assault and trafficking, calling them serious crimes against society, committing to providing victims the maximum protection under the law. That commitment to victim protection just should not end when a case is closed or when a survivor becomes a defendant. Research and common experience show many incarcerated women were first victims of abuse, contributing to what experts call the abuse to prison pipeline. We see this over and over again with so many incarcerated women report experiencing domestic or sexual violence prior to their incarceration. And in fact, a report just issued by the Department of Commerce in this state, I believe today, noted that, and the report is Increasing Safety and Community Support for Survivors 2024 final report, highlights how systemic inequities and trauma disproportionately drive women, specifically women of color, into the justice system. And I've been fortunate to be a part of a program called Survivors First in King County in partnership with the YWCA, where we identify survivors in the justice system, establish a clear link between their abuse and the crime, and then divert them from prosecution. This is typically in lower level felonies and in misdemeanors. It's become a model for other states. And it also tells a clear story. Survivors are often being prosecuted for actions directly tied to their abuse. HB 1591 applies the same principles found in Survivors First and in Washington's many decades of laws protecting victims, and applies them in this particular act. We recognize other factors shape behavior through sentence alternatives for veterans, individuals with mental health challenges, and those with substance abuse disorders. This bill simply extends that recognition to survivors of abuse. It is narrow and targeted, Survivors must prove their abuse was a significant factor in their crime. Courts retain full discretion to deny relief when it isn't warranted. Right now, victimization is rarely, if ever, considered in sentencing. According to the Caseload Forecast Council's recent report, in 2024, there was only one exceptional sentence downward for crimes committed under duress, coercion, or compulsion. HB 1591 gives courts the ability to recognize these realities and ensure justice is fair. HB 1591 reflects the values that this body upholds every day for supporting survivors and addressing trauma, and assures justice is informed by the realities of abuse. Thank you.
Well, thank you very much, David, and thanks for your leadership over the many years, but not just in the state, but actually across the world. I know you're working with many parties on reducing the harm from domestic violence. We've had this discussion many times, and some conclude that, well, yeah, you may be a survivor of intimate partner violence, but you committed a crime, and you need to be held accountable. So that shouldn't excuse you. So can you give some specific, you've been dealing with this case by case by case. I don't know if you can give some examples of where the link, the nexus between being a survivor and becoming a defendant in court is just so clear, and why this bill may be necessary.
Well, I think there is often ongoing abuse that is not known at the time. And we see this, I think frequently we see it in domestic violence cases. So in the Survivors First program that my office has with the YWCA, where we diverted, I want to say 240 cases last year. A lot of those cases arose out of a domestic violence incident where law enforcement was responding, charges were brought, and there wasn't just a great understanding that the suspect in the case had been a longstanding victim. In fact, it's very unusual for courts, and really for my colleagues as prosecutors, to look at where someone has been a prior victim, even though Washington has really good records about this. So if you go into AOC's records and you're looking at somebody's criminal history, it lists where they've been a defendant and where they've also been a victim. And so we will see instances where people have been a victim and an ongoing victim in multiple different instances, and you have defendants and abusers who are very manipulative, and we can make a decision and a connection between their ongoing abuse and the particular case. So that's one example. We'll see it even in kind of lower level cases like DUI, someone who is in flight from domestic abuse, and we can show and make that connection, but is now facing a criminal sanction, or someone who is under the coercive control of an abuser and doing crimes as a direct result of their abuse. We see this in trafficking cases all the time, and we see it in domestic violence where defendants will use victims to commit crimes on their behalf, whether it's holding the firearm or helping them in whatever crime that they take place. Mm-hmm. So I think we've seen it routinely, and I guess the question is how should that be reflected in our sentencing laws? Like right now, it's not reflected at all, and it should be.
Do you know a number? I just read yesterday, 2 days ago, that Oklahoma has just enacted, Governor Stitt just signed the Survivors Justice Act in Oklahoma. Yes. So we're not up to date with Oklahoma. I'm just wondering if there are other states who have enacted similar laws.
So New York has had this first, the Survivors Justice Act in New York. Oklahoma, you're right. I understand that Minnesota, Illinois, and California also has this kind of in the works, and I expect that to happen very soon. I think it is just a recognition, Washington's laws especially say that what we do for victims is so important, that what they've gone through is so impactful and so terrible. And we know people are driven into the justice system by abusive experiences. We know this. Anybody who's in the criminal justice system knows this. All the research points this out. And the question is whether our sentencing laws should reflect that. And the way they're written right now, it doesn't. Because when we look at just the way that the exceptional sentence system works for survivors, it was used once in the entire state last year. It's not a functional system. And I think what is good about this particular methodology is it is tying the actual underlying abuse to the acts, and it's leaving to the courts to make those determinations. And it's done so in a way that is thoughtful.
Yeah, thank you. Chair recognizes the Vice Chair.
Thank you, Mr. Chair. I just first want to say thank you, David. I appreciate you so much for that. You are one of few prosecutors that really center trauma and abuse of defendants and criminalized survivors. And I wish we could have done this bill together, but it's okay. I'm really happy that Chair Taylor had more time than I do. But I wanted to ask you about accountability and we talk a lot about accountability, and some people feel that you have to have punitive consequences to be accountable. And so from your perspective in these cases, what is the accountability of the survivor who was the victim but now is the defendant in these cases? What's the accountability?
Yeah, Rep. Simmons, that's a great question. And I think, there is discretion built in for courts here, right, as to how they wish to utilize the sentencing provisions. And the legislature has done this in other areas. When we look at the mental health sentencing alternative, even when we look at DOSA is a very structured approach to this issue. Mental health sentencing alternative is probably a more broad-reaching effort. But in either way, there's not, under either of those frameworks, we're not saying the individual is not accountable for what happened. The question is how much punitive response should be and how much kind of mitigation should be allowed. All this bill does is allow for it to be considered, right? It doesn't mandate it. It doesn't say in one way or another. It's giving courts discretion, which, I know this body is constantly debating how much discretion to give courts. Should we limit it? Should we grant it? I think when we look at Washington's history about domestic violence and sexual assault, and we look at the longstanding legislative intent, both in the criminal and civil realms, that this is the type of discretion that courts should have. Courts should be granted this type of discretion because the discretion they do have right now under the exceptional sentence provisions is just simply insufficient, as evidenced by the fact that only one case was done last year.
Thank you. Chair recognizes the ranking member.
Thank you, Mr. Chair. So the question that I have is two-part, if that's okay.
Oh, of course.
First of all, the prosecutors, must, I would imagine, recognize that there are lots and lots of people that have been traumatized, that have been abused, that have been sexually abused, and they do not go on to rape people, rob people, murder other people, because inherently we recognize that there's a universal language of crying, tears, fear, pleading, begging, please don't hurt me, please don't kill me. So I'm asking, do the prosecutors recognize that? And also, how many times are, if we're talking about recognizing somebody as a victim, if they've been abused, do they get to victimize somebody else, destroy somebody else's life, or end somebody's life before society has a right to say enough's enough?
Yeah, Representative, that's a key question here, right? How do we address that? And I think, when we look at this is about discretion, right? There are plenty of cases where someone's pre-existing trauma, this is my daily work, someone's pre-existing trauma is not an excuse for what happened. It's just not. And we're going to go to trial, and there's going to be accountability, and people are going to go to prison as a result. What this bill represents, though, is a narrow and targeted approach. First, you have to have survivors have to prove it, right? They have to prove their abuse was a significant factor in their crime. The burden is on the survivor, which is a big deal. And courts retain full discretion to deny relief when it isn't warranted. So we are giving courts some measure of discretion to do this. And I think that's appropriate. I think especially in this circumstance when Washington has such a strong commitment to this issue and the current tools that we have are just not sufficient. And I can tell you, having been a part of the Survivors First program since 2018 now, that my eyes have really been opened about this. Like we've had hundreds of cases come through. And we've had an enormous amount of success, which is why the program has expanded to now Oregon and Tennessee, of all places, is a huge adopter, and as Alabama is as well. And one of the things that you're able to do is to look at the underlying crime, look at the actual victimization, and then, wrestle with the questions that you're posting. I think your questions are exactly right, but we shouldn't not ask them. We should lean into them. And that's what this bill allows us to do. Whereas right now, that doesn't matter. We should have the ability to have this type of discretion, to have these types of conversations, because that's what being fair is all about, especially to a population of individuals who we hold dear.
Thank you. Chair recognizes Representative Griffey.
Thank you, Mr. Chair. Thank you, sir, for your presentation. Don't you, as a prosecutor, have that ability right now to not bring charges? Why do you want to transfer that decision over to the court?
Yeah, I mean, we do, but I think, the ability, the recognition of it in law is really important, because I think for prosecutors, you're following the law, and right now, this is not a part of the consideration. And I think having things written in law matters. What you as a body say matters to us. Of course it does. We're the law enforcers in all of this. And when you say that these things are things that should be considered, it goes a long way. Now, do I expect this to be used on an enormous number of cases? I don't. And I haven't seen the fiscal note coming out of it, but I can tell you it should be very modest. There's not an enormous number of cases here, but it is kind of a question of fairness at its fundamental level. And you're right, prosecutors have decision-making authority, law enforcement has decision-making authority. We're saying also as part of that, court should have decision-making authority.
Thank you, Mr. Chair, and thank you, sir.
Yeah, thank you very much, David. I gave you a lot of time, but it was worthwhile. So thanks again for the great work you do. We're going to ask the Coalition Against Domestic Violence, Lee Hofheimer, if you're with us, and then we will hear from WASPIC and WAPA.
Good evening. Thank you, Mr. Chair and members of the committee. My name is Lee Hofheimer, and I'm testifying on behalf of the Washington State Coalition Against Domestic Violence. House Bill 1591 provides critical relief for survivors of domestic violence, sexual assault, or human trafficking whose crimes were directly connected to the abuse they experienced. Because nearly all incarcerated women and trans people are survivors themselves, this bill allows for judicial discretion, allowing judges to weigh the history of survivors' experiences for sentencing alternatives, resentencing options, and erasure of past convictions where the crime was tied to abuse. Survivors who are not criminalized and diverted to community supportive services reduces recidivism and reduces the number of times people return to abusive situations. We're incredibly hopeful and excited about this vital legislation to bring justice to marginalized survivors. Thank you for listening.
Thank you very much, Lee. Now let's hear from the prosecutors. I'm assuming, Russ, that there's a wide range of views among the membership of the Prosecutors Association, so I'd like to hear about the response.
Yeah, thank you. And Mr. Chair, members of the committee, I'm Russell Brown, the Executive Director for the Washington Association of Prosecuting Attorneys. Let me first just by acknowledging tremendous respect for David Martin and their office's work. Their Victims First program is phenomenal. It's a great program. And David has a long history and being absolutely victim-centered, and his approach, his team does a great job. I'll highlight just a couple of things. We are testifying with concerns today, and primarily I'll start with the resentencing. This is one of about a half a dozen different bills that would offer resentencing, and I just wanted to reiterate there is no capacity. In fact, there is less than no capacity. We do not have enough prosecutors. We do not have enough defense attorneys. There is not the capacity to do this, particularly when you look at the bulk sum of all of the different resentencing provisions. So for my members, that is a non-starter. So then let me then take away that practical piece and talk about some of the issues as we read through this bill. I'll highlight that currently in law, there are about 6 or 7 different enhancements that we actually think would apply. And again, enhancement runs very similar to a sentencing alternative, similar to how this is drafted, I suppose. Judge has discretion to go below the sentence or the standard range with those enhancements and factors, and we look at 9.94A, 5351A, C, D, E, H, and J, all of which we think apply in many of these circumstances. This is also very expansive. There are a few exclusions, namely ag murder, murder one, homicide by abuse, individuals who could have sex registry. It leaves a whole bunch of other type of crimes that we also think are serious. Murder two, assault one, vehicular homicide. And the victim isn't necessarily tied to the nexus of the crime, meaning if I am being abused and I go out and shoot my neighbor or assault my neighbor, even though I'm being abused, the victim there is real. And in some ways, this has the impact of erasing some of that, which is a concern to us. In some of our other language, some of the other sentencing alternatives, including the mental health sentencing alternative, the victim is given a strong voice. This completely misses that piece of it, which we think is really important. So there's not only is there not a requirement to hear from the victim, there's no requirement for the judge to kind of balance. Yes, Russ was being abused. However, Russ went out and committed this harm. How do you do that? And because it's specific in one and not in here, I think you could read that as saying it isn't necessary. You don't necessarily have to have the balancing. We also would highlight the unfettered discretion in Section 2 too. So most of our sentencing alternatives or sentencing structures provide some structure. Mr. Martin mentioned DOSA, for example, and that takes depending where you fit on the sentencing structure, it has almost a calculation. Where this just says if you're charged, for example, with murder 2, you can get no jail time. You can have a little bit of community custody. And for us, that seems like too much, that we need to dial that in and have a little appropriate balance, the nature of the harm versus the nature of the conduct. But that's missing in this. It also doesn't have any limit to the number of times you can use it, right? So if you could establish that you were being a victim or survivor, and that would allow you to have your crime basically wiped out, or not necessarily wiped out, but your sentence would be mitigated to where you could almost serve no time. You could go right out again, commit another crime, and you're back into the same position seeking that alternative, and there's no prohibition against that. Nothing about prior history restrictions or prior failed sentencing alternatives, all things which are applied in other sentencing alternatives. Again, I think these are things that could be worked on in this provision. There's also documentation for the sentencing that is different than the resentencing, and we just wanted to raise this piece. It almost requires in the resentencing, one official documentation and then one maybe less official. So you could have a police report, a protection order, or something like that for resentencing, but that's not required in the sentencing. So again, it seems that those should be at least consistent, and that you produce something that would be a little more of an official document rather than just what this provides, which is a statement in court or someone else to make the statement. And again, respecting that the dynamics are going to be complicated. The resentencing offers a right to appeal. There's no requirement that right to appeal so if I were to seek a resentencing and it was denied, I get an appeal right, and as soon as that appeal is done, I could seek a resentencing again and have another appeal right. There's no time frame, there's no limit on that, which creates this cycle of unending appeals, which we also think would be unfair for a current victim who was part of the victim survivor's crime. And also the vacation, there's no structure or consistency here, similar to our other language. Again, you can rely simply on a statement. You can also have crimes vacated if you have other pending charges. So again, if you have this dynamic, this seems to absolve the conduct of someone, which I don't think is the intent, but it absolves that conduct. So you could not only receive a sentence that is well below the standard range, you could have all of the other crimes that you have in your history that could be vacated without the same kind of time frames, conditions in place. So the handful of things, again, happy to keep working on it,
Yeah.
but those...
So hold on to those notes, because we're going to be engaging in some refinement of this, but very, very helpful. Appreciate that. James, go ahead.
Good evening, Mr. Chair and members of the committee. I'm James McMahon, Policy Director with the Association of Sheriffs and Police Chiefs. After that, I feel like my notes are written in crayon. So we believe that we should appropriately consider a person's victimization at sentencing, appropriately being the key word there. We don't support a policy that, whether intentional or not, enables a person's prior victimization to create more victims. That's antithetical to our goals for public safety. We ask, and this question, or sorry, the language in this bill poses the question: how long is a victim? Who gets to decide that? Frankly, that choice belongs entirely to the victim themselves. I'll point out the first sentence in this bill, notwithstanding any other provision of this chapter. This chapter that's referenced is the Sentencing Reform Act, which means that all of the sentencing grid means nothing in this circumstance. That, as you heard from Mr. Brown way more eloquently than me, a judge could sentence somebody to anything that they want. Due process, equal protection, all of those things we think come into play unfairly in this circumstance. We also look at section 1 sub 3A, which is found at the top of page 3, which is a list of the current law provisions that can be totally ignored under this. Assault 1, assault of a child 1, sexually violent predator escape, 3 strikes offenses. A person could be up for their third strike and use this to avoid all of that. Again, we should appropriately consider a person's victimization at sentencing. We think the plain language of this bill just simply goes way too far. We'd like to be part of this discussion. Some of the boundaries that we would suggest is acts of premeditation, sexual acts against children should be absolute non-starters in that conversation, that there should be some reference to the Sentencing Reform Act and the sentencing grid that we have. Sure, maybe we can adjust that a little bit in light of that, where we've actually tied in. Frankly, I don't think the language in this bill accurately reflects what I heard from Mr. Martin. I think I agree with virtually everything that he said. We're just not reading that here. And we think that really needs to be tightened up before we can be comfortable doing anything other than asking you not to move it forward.
Great. Thank you very much. Again, very instructive comments. And this is, the lawmaking process does involve words on a page, right? So we have to be extremely
often
careful.
Lost in the conversations.
Don't forget the grammar. So, okay, thanks very much. Let's hear now from Elizabeth Hendren.
Thank you, Chair Goodman and committee members. My name is Elizabeth Hendren, and I'm an attorney with Sexual Violence Law Center, a nonprofit statewide law firm that provides free legal assistance and representation to survivors of sexual and gender-based violence of all genders and ages across Washington. On behalf of the survivors we serve, we ask you to vote yes on HB 1591. Intimate partner violence, sexual violence, and trafficking have long been acknowledged as drivers of incarceration of women and girls in particular. The Bureau of Justice Statistics and many scholars have documented this link for decades. The sexual abuse to prison pipeline is a term used to describe the staggering rates of sexual violence among incarcerated women and girls, and has been detailed in a report from Georgetown Law Center, as well as many other sources. At SVLC, we have seen this reality firsthand. We receive calls and requests for assistance not for criminal defense, but protection orders and other victim legal issues from women in jails and prisons across the state. I personally ran a civil legal clinic in both women's prisons in Washington for 10 years, and nearly every woman I met with not only had experienced past violence, but continued to fear what would happen to them once they were released and would be exposed to the abusive people in their life once again. I really want to thank the bill sponsors for bringing this thoughtful bill. It recognizes the reality of so many survivors who have been overlooked by our mainstream gender-based violence movement, and it provides a needed remedy. We appreciate how tailored this bill is. We are also deeply concerned about cycles of violence and creating more victims, and for this reason have not generally weighed in on sentencing and resentencing bills. We believe the details and level of specificity which is required by this bill will prevent this remedy from being misused. We do look forward to working with this committee on any ways to continue improving this bill to address the concerns, but urge you to please support 1591. Thank you.